Now, we're going to start again, if everyone could pop back into their seats. Peter's the next speaker, and he's going to talk about Executors Commission, which is always an interesting topic and close to your heart.
Thank you, Your Honour. I was in large measure responsible for Simon Pitt not turning up this morning. Her Honour was very coy in talking of personal matters that stopped him from attending. In fact, he's the proud father of a second baby boy, and baby and mother are very well. Simon is very sleep deprived. Paternalistically, I invited him to spend more time in bed and less time up here at the lectern, and he finally took up my urgings. It would have been good for him to have been here, given his role in cases such as Simmons and the like, but I think as a result of Jeremy's adding comments that had been relayed to him by Simon, he's making his presence firmly felt in absentia. The other matter that I just wanted to say in introducing my particular topic today, I loved the segue that Jeremy just engaged in to bring the matter back to Her Honour in relation to his absolute last comment and referring to Her Honour's judgment in Larkins and Borg. I thought that was a masterstroke, and especially I'm reminded of that case because, as I recall it, there were some horrible blunders made by the losing plaintiff in relation to her attendance at football matches, in particular grand finals where North Melbourne was supposed to have played and won. So in grand final week again, I thought that segue to Larkin and Borg was very enlightening. The other matter that I need to refer to back to Jeremy really comes about as a result of the excellent paper that he's produced. I was nearly caught unawares by his sudden swerve to produce such a comprehensive and updated paper, because when we were in the planning stages of this particular morning briefing, it was all to be done on the basis of Q&A. And I love Q&A because, well, one can just front up and there's hopefully not too much preparation, and the questions are not too firmly considered, especially at this time of the morning. In fact, I had done a Q&A that Michael inveigled me into when he had not one of his breakfast briefings, but one of his breakfasts with guest speakers, and I'd been the stand-in for Tony Jones when Barry Cassidy had released his book on the last election, well, the last election before the last, the penultimate election. And I'd found that it had been a fantastic experience, and so I was looking forward to something of that ilk, and Her Honour was going to be, well, I wouldn't suggest she'd be a stand-in for Tony Jones, but Antonio Jones, yes. So when the email hit my desk in the early afternoon yesterday, and there was in the attachment this magnificent paper on summary judgments, I thought, well, Pascoe, it's time for you to move in another direction, get something down in writing, which I have very quickly done, and in part I'm thankful to Eleanor Coates, also a barrister specialising in this field from Green's List, for giving me the synopsis of the estate of Foster, and I was able to quickly put that into the second page. But let's just have a look at the paperwork that I have produced in very short time. It's nowhere near the standard of Jeremy's learned paper, but what I've done is I've styled it in the form of an aide memoir for Q&A, And in discussing matters with Eleanor, just in the short drinks break there, we reached the conclusion that I was both asking the questions and providing the answers, which I think is probably a gloss on the way in which this particular matter should be running. But as I say, it's an aid memoir just to get some material off and running. And so provocatively, what I've done in the first paragraph is to ask, well, how many wills made post-2005 contain commission clauses for solicitor executors and there's no Rule 10 letter? Now, hopefully the thought is going through none of your minds, what is a Rule 10 letter? Okay, I'm sure looking at this eminent group that we're all very familiar with our Rule 10 letter, and we put them out to our clients religiously. But for those who can't just bring what Rule 10 really is all about to the tip of their mind, I've put it in footnote 1. And you recall that this is the rule that really took a long time to emerge, despite the fact that it was brought into existence in 2005. And it requires a practitioner who draws a will in which the practitioner or an associate is the executor to inform the will maker in writing before the will is signed of any entitlement of the practitioner or practitioner's firm or associate to claim commission. If commission is to be claimed, then the person making the will might appoint another person as executor who might make no claim for commission. And the middle dot point is if the will includes a provision entitling the practitioner, etc., to charge legal costs, then that's got to be firmly brought to the notice of the client. Now, the reason why we keep perhaps referring to Rule 10, as I indicated, was the fact that it really seemed to not get the prominence that it deserved as a rule change. And I recall doing a paper, it was a couple of years ago now, and I had to do much more work for it and produce a much more learned version. And I'd gone through and, for example, I'd noted that when the late, as he then was, Master Evans had delivered his judgment in re McMillan, he had spoken about the need for a rule change in Victoria. And when I look back at the exact delivery or the timing of the delivery of that judgment and the timing of the introduction of Rule 10, excuse me, it was clear that Rule 10 was in existence at the time that Master Evans produced that judgment, and that it had just flown under his radar. And it was also the fact that looking at the our two-volume in Victoria Wills Probate and Administration Service, that the change had really not come onto the radar of the learned authors of that work, because it took them about 5 years before they did anything other than to refer to Rule 11 of the New South Wales Professional Conduct Rules. And another example of how it missed the profession was that when His Honour Justice Habsburger gave judgment in Schmulwitz and Recht, it was very evident that neither Mr. Recht nor Dennis Liner of his firm had been aware of Rule 10 at that time. So even although its prominence has been probably made more so since about 2010, I still have this nagging suspicion that there may well be circumstances where the need for the letter is not recognised and the rule hasn't been complied with. I'll say no more about that, but we'll move on to the second aid memoir that I referred to, and putting it in the interrogative sense, I've asked how many wills are in existence containing solicitor charging clauses of the following kind. And there I set out one, and I've emphasised what is the area of interest. In short, and you can read it as I'm talking, but it's an attempt to extract charges that are both professional and also at the same time to extract remuneration, which is fixed by commission at 1/2 of the rate payable to a trustee company. Now, we're probably all mindful of examples coming across our bows where there are inappropriate charging clauses, but this one came across my desk within the last, say, 6 weeks, and I gave very clear advice as to what could and couldn't be done, and fortunately the solicitor didn't persist in doing anything more than charging for professional services at professional rates. Now, as I said, from my experience, there are many clauses in wills drawn in days gone by that really do offend the rules that we know and have recently been emphasised, that are sometimes very shortly expressed as there can be no double dipping. That's one way of expressing it in a very short manner. And secondly, as we know from His Honour Justice Habsburger's decision in Schmulwitz and Recht, that when one is referring to fixed rates of commission, such as this one, where it's 1/2 of the rate payable to a trustee company, one needs to ensure that one's client makes informed consent. And His Honour's judgment in that case sets out the basis in which that informed consent may be given, and particularises the sorts of features that constitute such consent. And it makes valuable reading time and time again if you're faced with the need to ensure that your client does indeed have that particular consent. And it may involve a trip to another solicitor to absolutely make sure that there is no prospect of this particular means by which you can extract remuneration would be held to be invalid by a court. And it certainly was in Schmulwitz and Recht, despite the fearless advocacy of Mr. Goldblatt of counsel on behalf of his clients. But nonetheless, His Honour was very firm in his outcome that informed consent had not been given. We'll pick up Schmulwitz and Recht in another capacity or another guise shortly, because what I do is, in the third question, I ask what is meant by the very large estate argument. And what I've done in Appendix A is to give the results of the Victorian cases in some large estates. What's large is often a matter of impression, but starting with 7 figures is always a good start. So what we have when we talk about the large estate argument, it's a matter that really came to my attention reading a New South Wales decision in the area, and the particular decision there, I haven't referred to it in a footnote, but it's a decision of Hawkins and Barclay Brown in 2010 by Mr. Justice Slattery in the New South Wales Supreme Court. And the large estate argument really is that in large estates, fixing by percentage is just going to give the executor too large an entitlement to commission. It's a little bit like when we're referring to, particularly in days gone by, real estate agents and their charging of commission, and we're into our Bayside and inner city suburbs where prices are high relative to other areas of Melbourne. Now, that particular aspect of percentage applied to a large estate gives too larger or an unexpected bonus by way of the amount of commission was something that not only was the subject of some submissions before His Honour in Hawkins and Barclay Brown, but it was also something that Stuart McNabb of our bar had raised when he was arguing a matter before Associate Justice Gardner. And to take the point, if I could refer you to page 6 of the material, where I've put footnote 4. And there, His Honour Associate Justice Gardner refers to the fact that Stuart McNabb submitted that there is a rough rule of thumb in Victoria that with an average estate, as to the amount realised and the difficulty of administration, capital commission is reckoned to be in the range of 2 to 3%. There's that percent coming home. We tend to think and talk about commission in terms of percentages. He says that in this particular case, having regard to the size of the corpus, and this is the estate of Buckland, where the corpus was in excess of $2.8 million, that range is inappropriate. Inappropriately large would have been Stuart McNabb's submission. What His Honour Associate Justice Gardner went on to say, without specifically referring to that submission, was that I agree with Mr McNabb's view that the scale set out in the text of Master Vance, with which some of us are familiar when we need to advise on these sorts of matters, and the guidelines in the South Australian case of Re Bar Smith are obsolete because of the dramatic decline in the value of money. That was also the view of Justice Wendayer in the estate of Creer, the estate of Peters, where His Honour there made similar observations in regard to Vance and Bar Smith. His Honour Associate Justice Gardner went on to say, in his submission, Mr McNabb surveyed a number of Victorian and interstate authorities and sought to draw out the particular percentage of commission awarded according to different factual circumstances. His Honour Associate Justice Gardner then said, however, whilst this was interesting and an edifying document, when I come to exercise my discretion under the section, the approach is to review what work was done by the executor, what difficulties were encountered, and the length of time that it took. This is because the section requires recompense for pain and trouble. And in that last 4 lines, what His Honour is doing is echoing the sentiments from the author, the learned author of Vance, which is now quite outdated in some respects, but in other respects it is still highly relevant to our analysis of these sorts of claims today, because what the author of Vance had said at page 182, and I think it just bears referring to so that we're very much in tune with what is an essential component of a claim for commission. The author said, the correct approach to the matter of quantum recognises the fact that the master's task and objective is initially not that of finding the appropriate percentage rate. It is rather to determine the amount of commission adequate to recompense the executor for his pains and trouble. The amount of commission will depend upon the extent of the pain and trouble expended, not just only in the realisation of particular assets of the testator, but in the general administration of the state. The question of percentage comes into consideration only after the master has fixed an amount in his mind, which he wishes to translate into percentage terms. The necessity for this arises from the requirement in the Act that the amount of commission is not to exceed 5%. So, to summarise, while we tend to talk and think about percentage outcomes, we must start with what are the pains and troubles, and how does that parlay into a dollar amount of money, and then having reached that particular point in our analysis, we then look to and calculate what that would amount to as a percentage. And that is well illustrated in the first of the cases in the appendix that I've produced, because remember, this is an Appendix A that refers to the large estates, and there aren't many cases that are reported in relation to Executors Commission anyway, and fortunately a good number of them are fairly large estates. So but the first of them in Rees Stone, Patterson and Halliday, the amount of the estate there was approximately $6 million. And the responsibility for administering such an estate had been recognised, as had the unreasonable conduct of the beneficiaries been taken into account. And Master Evans, the late Master Evans as he then was, awarded $120,000 by way of commission to one executor, the other having renounced her entitlement to commission. This was the equivalent of 2% of corpus, but that was the second tier calculation, the reference point. His Honour Justice Smith really said in the material that I've quoted there, look, I think that was probably on the higher side of where these matters might come out. It might to some seem generous, but I'm not going to say that it was inappropriate. And it was left at that particular figure. And Patterson and Halliday is a valuable case because His Honour there set out the relevant factors to be considered by the court in a grant of commission. I haven't put them in the material Appendix A because it's been produced for another purpose. But I commend that part of the decision to you if you do need to analyse a claim for Executors Commission. As I indicated, we would return to Smulwick and Recht, and this time we're doing so by referring to the decision of His Honour Associate Justice Mukhtar, where the professional clauses, the professional charging clauses and the amount of commission were very much to the fore. A $6.5 million estate, and the only purpose of really noting His Honour's judgment in that case, because it is more prominent for the later assault on the informed consent point before His Honour Justice Habsburger. But at para 18, His Honour Associate Justice Mukhtar said that Executors Commission of 3.5%, which was the amount, the specific amount that was placed into the charging clause in that case. His Honour said that he knows from deciding Executors Commission cases, and I just interpolate to say that there are none that I know of that His Honour has actually brought down a written decision, but obviously there are these Executors Commission cases that are decided that are not the subject of written decisions. And going back to the text, His Honour said that that particular percentage tends to be at the top end of the scale, at least for a corpus of an estate of this kind, $6.5 million. So we then have two further cases to deal with, and the first of them is the estate of Boundy, where there was a corpus of $4.1 million. The short facts really do indicate the complexity of the pains and troubles required. There was the sale of 10 properties required. There was an acrimonious dispute over the removal of 2 other executors. And importantly, and I have underlined it or bolded it, His Honour Associate Justice Gardner specifically discounted his award of commission for unexplained large legal fees that were incurred on the behalf of the estate, approximately $100,000 worth. And I say that, continuing on in the particular column over the page, the importance of the legal fees is that a claim for commission can be lessened, but I say in the footnote, not extinguished, because of the extent to which the non-legal executors' functions are performed on behalf of the executors by solicitors retained by them. So that's an important point to build into your analysis, just how much of the lawyers representing the executors actually charge for services performed. Another important aspect of that case, referable to proving pains and troubles, in particular the troubles, is what diary or chronicles have been kept by the executors, and in that case there were none. And that severely limits the strength of the claim. In that case, we had $4.1 million, and commission was awarded at the rate of 1.45% on corpus, 2.56% on income, a total amount of $64,000. I've put those around in the sense that I've concentrated on the percentages first and then given you the amount. And that was split between the two executors so that they each received $32,000. Now you compare that with what His Honour Justice Smith thought was a little on the high side, namely $120,000 in Re Halliday, Patterson and Stone, and you get some sort of sense of where the courts are thinking about these sort of matters. The final matter was in the estate of Buckland, and we had a corpus of $2.8 million there, income receipts in excess of $2.2 million. Again, in the third column, I just ask you to turn the page. I've footnoted material there that we've already gone through, but taking up again the point of what are the professionals' fees that have involved, that have had input into the estate. The executor had engaged an accountant whose fees were $13,310. There was no evidence of the legal fees paid. But the executor did not keep a diary, save and except for certain entries in the personal diary and several visits relating to journeys to Adelaide and Melbourne on estate business. But she didn't keep an extensive diary, and again, that's bringing about a situation where the claim is not on such a strong foundation. But nonetheless, His Honour Associate Justice Gardner did award commission on the corpus of $2.8 million in the sum of $56,000, which again equated to 2% of the corpus. So when we start to look at the combination of all of those comments or parts of decisions made by their honours, we could see that when the estate gets large, a rule of thumb is that, subject to the circumstances of the particular case and the particular pains and troubles, an amount of commission might be fixed in dollar terms, but the reference point by percentage would rarely exceed 2% of corpus, and certainly Associate Justice Mukhtar was correct in saying that 3.5% on $6.5 million was right at the very high end of the scale. If I can quickly move to the last of the questions from my aid memoir. What I've done in the fourth of the questions is to simply ask, what is the profile of a successful claim for commission by a solicitor executor? And as I say in the footnote on page 2, I'm indebted to Eleanor Coates for this synopsis. The estate of Foster, this was, the solicitor involved was David Rees-Hackford from the Latrobe Valley, and as is indicated, I think, in the penultimate paragraph of the synopsis there, the estate was a relatively small one, about $342,000, and the will did not contain a charging clause, so that the matter had to come to court, and as I've said, even although small, the case was complex, the circumstances were difficult. One of the features of this particular decision, and it was the decision of Associate Justice Daly, was that she took a much more favourable view of the role of solicitors as executors than Master Evans, as he then was, had done in Re McMillan. You may recall, those of you who are familiar with what was a very famous decision, in Re McMillan, Master Evans to some extent chided the profession for engaging in conduct as solicitors and executors that would almost inevitably bring about conflict of interest. In this particular case, Her Honour Associate Justice Daly took a much kinder view of the role of solicitors acting as executors, and in particular drew attention to the relative dearth of good, competent professional advice that may be available in the regions, the country regions, the rural regions of not only Victoria but of any other state. And it was quite appropriate that she recognised that, particularly given the facts of the case, because she was very complimentary of David Rees-Hackford's conduct in assisting his client in very difficult circumstances. She was the granddaughter of the deceased. She had a disability of some kind. She was in acrimonious conflict with her mother, who was the part for plaintiff in the case. Excuse me. And the court recognised the Herculean and often unrewarded efforts of Mr. Hackford-Jones in bringing about a settlement of the matter, and charging what were quite modest legal fees, and so that at the end of the day he was awarded for his pains and troubles, which were not obviously the subject of any double dip in relation to his legal fees, at the rate of 3%. There is another important feature of that case, because if you read the judgment, it was really a case where I think it was Ursula Stanisic of counsel who acted for the contradictor, that she really took every point in a very robust attempt to try and knock the claim out. And none of the points robustly put on behalf of her client were successful. That is, the applicant executor came away smelling of the proverbial roses. One of the things that had been a point of attack was the fact that he did not provide a detailed bill of costs. And that had been the subject of some very emphatic comment by His Honour Justice Forrest in the D'Alessandro case, and the fact that there had been no detailed bill of costs provided was said to be a major sticking point, because it really didn't enable the client to discern what in fact had been charged for professionally and what might have been said to have been part of pains and troubles for Executors Commission justification. In the particular case, as I said, the solicitor had not provided a detailed bill of costs, but he escaped unharmed from that, what might have seemed to be an omission on his part. As I say, Her Honour Justice Daly took a favourable view to his conduct overall, and let that one pass through to the keeper uncriticised. So that I think we're probably at the point of arriving at a conclusion whereby if a detailed bill is sought, we just perhaps need to step back and think, is it really required in all of the circumstances? Perhaps that's not a decision you as solicitors might necessarily make in your own interests, but it might be something that you take some outside advice on before you fire off the letter saying one way or the other in response to the question. And I'll finish my comments on Executors Commission by reminding you of the sin of conduct of both Mr. D'Alessandro and also my client Peter Santo, in a case in which I acted for him. You do not write a letter to the beneficiaries seeking commission and either expressly or impliedly saying that, well, if they agree, they'll get a very quick distribution, and if they don't, it's going to take one heck of a long time. In my defence, Mr. Santo had sent his letter before I was involved, and the case came before Associate Justice Daly, contrary to my advice. All right, thank you very much.
Can you hear us from here? Now's the time for Q&A. Thanks very much. So, are there any questions of any of us that you might like to ask in this last part? I should add on that final note, Peter, the two solicitors in those cases ended up going down for disciplinary hearings, and they would report the error of their ways with the quick way of the long way.
Yes.
So be aware of that.
And not taking the advice of learned counsel.
Yes, indeed.
It looks like my strategy of providing the questions and providing the answers has worked, doesn't it? So thank you.
Well, it also shows comprehensive. Now, leaving aside Mitch, anyone else?
Peter, I was just going to ask you, looking at that note, footnote 4 about the scale in Vance and the Barr-Smith decisions are obsolete because of the dramatic decline in the value of money. Is that just saying that large estates are no longer calculated, looking at the way they were set out there, money is now worth a whole lot more, it's got to be millions rather than hundreds of thousands, and in those cases the scale and the notion is still right. You don't get a big percent, you don't get a percentage on a great big estate because you'll be overpaid. And as the estate gets bigger, then the percentage is modified, but what's big is now a lot more in actual dollars.
I think it's a little more specific than that, although what you say is relevant to the matters that I put, that aspect of what is the large estate argument. But when you look at Vance and the graphs that are put there, and I hesitate to use the word, the parsimonious approach to the awarding of commission, I think it's very evident that inflation has just rendered that whole exercise involving graphs useless, basically. I think it's really that simple. It's really an economic point rather than a legal economic point. It was written a very long time ago. Not everyone has a copy. I have some copies of parts of pages. I would love to get my hands on a copy, but one is not available. It's a very ancient tome.
I think also you have to take into account that whilst estates might seem large, they can vary in terms of their content. So one of the examples are 10 houses, but often it might be one house plus money in the bank. And the emphasis is on pains and troubles, so that if there were not too many pains and troubles, then the commission would go down. But if there's a lot, then it will reflect that. And it depends very much on the task that you have to do, because you can get a difficult time for an executor who has to deal with unthankful beneficiaries sometimes or whatever. But the cases say you take into account if the executor had to deal with Part 4 claims, for example. And we all know being an executor is a thankless task, but really the recent cases, and there are very few reported ones, do focus on what are the pains and troubles that the executor has had to undertake. So it's really a factual exercise, which brings me to my point, mine would be my bonnet, which is dependent on the quality of the evidence that you put forward. That's important. So in those two examples that Peter gave, where there are no diaries or chronicles, it makes it hopeless for the judge or the associate judge in guessing what happened, because when people come to court, they're going to be putting the case as best for themselves, and sometimes people unconsciously or consciously remember the task might have been much harder than they thought. But if there's a contemporaneous note of what they did, or there's some detail, it's more helpful than someone's memory of it. I came across a great quote the other day when I was considering my issues about the quality of the evidence, and it was from an author in America, and I think she said, memory is a complicated thing. It's a relative of truth, but not its twin. And true it is. Barbara Kingsolver. Now, any other questions? Yes.
Peter, in the situation of the difficult cases, e.g. the Hackford-Jones or Boundy was difficult, it seems to me that those percentages are not high. They could be 5% plus. How is 3% going to be judged as 3 times more difficult than, say, Recht, where it was not regarded as difficult in the same way, and he got, may have got 1%, of course got nothing because of other reasons. I'm just not following why 3% was enough for Hackford-Jones, especially when you think that 3% of 300 is $10,000 or $12,000. And in Boundy, 1% of 4 million is $40,000 or something like that. How's it judged? What does the judge?
Well, I think if you approach it on the basis of Vance's comments that you fix an amount that's referable to the pains and troubles in dollar terms, and then the percentage really becomes just the reference point having regard to the rule of not exceeding 5% contained in section 65 of the Act. So I really think that's an important aspect of the analysis. It's like a lot of difficult exercises that judges engage in. It's a matter of bringing about some dollar amount that recognises pain, loss and suffering, or in our case, pain and trouble, loss and expense in other jurisdictions.
What goes through a judge's mind to work that out? Because the way you described Hackford-Jones, which I don't know, he should have got a lot more than the amount that was there, even taking into account it was a small estate.
Yes. Well, I believe that there probably is some historical resistance to going anywhere near an amount of money that would translate into 5%. I think in part that's drawn from the background of Vance's approach that dominated for many decades. And I did use the word parsimonious in respect of that. Because, based on your comments, I think you would look at them as I have and say that's a meagre approach to an outcome. And I think perhaps the other point is that this is an area in which there could be reasonable disagreement between those who ultimately decide. So that, for example, when we started off with Patterson and Halliday, His Honour Justice Smith said, well, look, 120,000, that seems generous to me, but it didn't seem generous to Master Evans as it was. So I think there's probably an historical background to it all, and then when a particular case comes to be decided, the capacities and the generosity, for want of a better term, of a judge or an associate judge will come to play.
I should add to that, Peter, and refer to the fact that in Hawkins and Barclay Brown, which Peter mentioned, Justice Slattery had faced or dealt with 2 arguments. So I've got a note here. The first was the award of commission in a large estate should not be calculated on a percentage basis, and that the executor should produce an hourly rate of work multiplied by the number of number of hours of work and calculate the lump sum. So it was an attempt to do a time-based calculation. Those arguments were rejected, and I'll read what he said. He said that in exercising his discretion in a large estate, the court can take into account the fact that if the executor's pains and trouble have indeed not been very great, the commission could be adjusted downwards. And he also says that he rejected the large estate submission. He also held that the large estate submission rejects the additional human and administrative burdens that an executor may discharge. And large estates can bring greater complexity of administration, more sophisticated and argumentative beneficiaries, and a greater risk of litigation. So you get back to the core issue, I think, is the pains and troubles and what the facts might be in respect of those pains and troubles. Now, yes?
I'm just judging from your comments. I mean, one tends to get involved as an executor.
I can't hear you, sorry.
One tends to get involved as a solicitor executor when the children are fighting.
Yes.
And the problem is then the question of lying in bed and sweating. So I decided, having heard your aphorism or whatever it is from America, that when I wake up at 3 o'clock in the morning wondering what the hell I'm going to do tomorrow at the executors meeting, I will write some notes carefully.
Excellent. How many of you have been involved in negligence actions, professional negligence actions, and you go to proof the witness and say, what did you do at that conference? And they say, I don't keep notes. Well, if you think of my job, what I have to do is decide on the facts. Now, it helps me enormously if there's a note of that conference, not just some memory 2 years, 3 years later or 5 years later. Memory's a tricky thing, like the football game. Yes, any further questions? You see, well, I think that we've done such excellent presentations, you two, that you've got very few questions. I thank you all for coming here today. It's been illuminating and interesting, and it's always helpful, I think, for the profession to have a concise summary and an explanation of how the matters are decided. So thank you very much for attending, and we'll see you in the next round.